Matter comes on for what we call an initial advisement pursuant to Rule 5. Typically, you can step back. You have a right to remain silent. To make any statements that can be used against you. You have a right to be represented by an attorney. If you could not afford one of the statutory guidelines, I'll appoint one to represent you at no cost to yourself. Any plea must be voluntary, not the result of any undue influence or coercion. Typically, you have a right to be advised of the charges. You have a right to be advised of the charges. The duty judge to make preliminary determination of probable cause to believe you're committed the offense of first-degree murder, which is a Class 1 felony under Colorado law. Ordinarily, individuals are entitled to bail. Given the nature of the charges, you are currently being held on a no-bond hold. You also have a right to have a jury trial and preliminary hearing to determine whether there's probable cause to believe that you're the person that committed the offense. Mr. Holmes, do you have any questions about that initial advisement? Thank you, Mr. King. Pursuant to CRS 18-1-1001, we are to enter a mandatory protection order. Any violation of the protection order can constitute a new criminal offense and or contempt of court. It is the order of the court: you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you were charged with committing. Shall vacate the home of the victim, stay away from the home of the victims, and stay away from any other location the victims are likely to be found. You shall refrain from contacting, directly or indirectly communicating with the victims. Shall not possess or control a firearm or other weapon. Shall not possess or consume alcoholic beverages or controlled substances. And is to further order the court you are not to commit any new offenses. Ms. Pearson, if you'd approach, please. Just signed the mandatory protection order. If you tender a copy to Mr. Holmes and acknowledge it received on the record. Thank you. Ms. Pearson, ordinarily, people request 72 hours for the filing of charges. What's your request at this point in time?
Sure, we are asking for the 72 hours since the local rule. Rule 5 only requires it without unnecessary delay, so we would be requesting until next Monday, July 3rd.
Mr. King.
But we do not object to that. If I may approach, however, I do have an application completed by Mr.
You may.
And Your Honor, at that time we will also file an amendment to the protection order that lists all of the cases.
Thank you. The court has signed the application to the appointment of public defender. Public defender is appointed to set the matter for formal filing of charges this Monday, July 30th, 9:30 in this division. Given the nature of the charges and the likely voluminous pleadings, I'm entering the initial case management order. Has counsel received a copy of that order yet? Thank you, Ms. Pearson. Did you receive a copy? Good. We'll make sure you get a copy. Essentially, what that's going to do, in order to track the pleadings, all people's filings will be captioned with a P with the sequential number thereafter. Defense will be a D with the sequential number thereafter, and I will identify my filings or orders with a C. In that we've had some filings already. The initial case management order, which I've captioned C2, does list the orders and motions that have been filed thus far. What I'd like to do is just recap them, make sure I'm not missing anything. So far, we've got C1, which is the EMC decorum order that I issued. We've got the P1, which is the motion to seal the search warrant affidavit and orders and case file, which was filed by the people. I did grant that. We've got outstanding D1, which is a motion for access to and preservation of the crime scene, which relates to access by the defense and their experts to the movie theater. We'll address that in a moment. We've got D2, a motion to limit pre-trial publicity. Along with that motion, I did receive a proposed order. However, I'm inclined to go ahead and just track Rule 3.6 and 3.8 of the Rules of Professional Conduct. Ms. Pearson, the people's position as far as the pre-trial publicity motion by the defense. Thank you, Ms. Chambers.
Judge, the people would ask for just that to be tracked.
Yeah. Court will be issuing the order granting the pretrial publicity. We'll make sure counsel gets a copy. Yes, I'm not adopting the defense order. I'm crafting my own, which will track 3.6 and 3.8. You may. We've got the D4, which was the objection to expanded media coverage and request for hearing. I did grant the request for expanded media coverage. I've not been aware that there has been a filing for a request for expanded media coverage at this time. Last indication I had from my staff, we have not received one. How would you propose we address that once we get it? Assuming we're going to receive one for the filing of charges, Mr. King or Ms. Pearson? Can we do that forthwith upon the receipt of the motion? Do you have any objection to that?
That would be appropriate at that point.
Good. Ms. Chambers, do you have any objection to that procedure? Ms. Pearson? We do have the motion for access to the crime scene and preservation. People's position on that? When do you anticipate that occurring? Are you in a position to give them reasonable access with 24-hour notice? All right. Court will issue an order concerning that. Anything further on that issue, Mr. Chairman?
My understanding is that the scenes all being part of
Did I misread your motion? Because I think your motion only addressed the movie theater.
I apologize if that was the case, Judge. We filed that on the fly on Friday, so we are asking, and I will amend the pleading orally now and in writing later.
Your Honor, I assume that they also want to be a part of held, and we will also make that available when it is safe for them.
Thank you. For the people, is there anything outstanding?
Your Honor, we filed this morning a motion regarding public access to University of Colorado records. Does the court have that in its possession?
I do.
And the court wishes further argument on that motion, we can file.
Okay.
Judge, we have been tendered that pleading this morning. We've had a chance to briefly review it while we preserve any right to file additional pleadings on that. As it appears right now, we would have no objection in joining the request by the people.
We're marked as T2 in accordance with my case management order. I'm going to grant that order. If in fact you feel it needs to be amended or have some objection after further analysis, Mr. King, I'll let you file a motion to amend.
Thank you, Your Honor.
Ms. Pearson, anything further for you?
No, Your Honor, thank you.
Mr. King?
Judge, we tendered to the prosecution this morning defense motions 5 and 6, which are notice of vindication of all statutory and constitutional rights and privileges and revocation of any and all previously given waivers of privileges, and motion 6, motion to allow confidential defense experts to be present for scientific testing of evidence. With regard to pleading 5, we're just asserting all of Mr. Holmes' constitutional rights, and this is just a notice of that. With regard to the scientific testing, I think that we're not really at that stage yet, but we are filing this in abundance of caution if I can put it together.
You may. Is there anything on either notice or motion for people at this time?
Your Honor, we have not acknowledged notice under Defense 5 of the invitation tax.
Thank you. Once again, anything further for you? Can I go home with this? You may.
No, Your Honor.
Thank you. That will be in recess.